You have to tell me what you need me to read.
I got it. We only got one. Let's go ahead and do that and take care of the business right now. And let's hear from our friends over at Conscious Strength. And literally, friends.
Big Pharma is officially on notice.
People drinking methylene blue and stuff like that.
Yeah, methylene blue, which was a fabric dye.
Yeah.
Yeah, it was a textile dye. And now they find it has profound effects on your mitochondria.
Yep.
Yeah.
This stuff works, man.
Do you know about methylene blue? Originally synthesized over 100 years ago, we are just finding out about its benefit as a supplement with its ability to help oxygenate the blood and amplify our mitochondria. People all around the world are using methylene blue to accelerate their brain power and support their energy levels. Conscious Strength. Methylene blue is pure USP grade, aqueous solution. Click the link to learn more and shop Conscious Strength now.
All right, Conscious Strength, get you some methylene blue. It's good stuff.
Does it make your teeth blue?
No, not really. It makes other things blue. But other than that, it's pretty good. I take it. I don't. Are you supposed to take it every day?
I don't know.
I take like a thimble, a dropper full, each morning that I'm on air. So Saturday and Sunday, I don't do it.
What are the benefits? The stated benefits?
Your mitochondria. So you're rebuilding it after seed oils have screwed it up for so long.
Okay.
I don't know. Jordan gave it to me and said, take it. And I said, if Jordan's telling me to take it, I'll take it.
Yeah, I'm going to try it. I think I have some on the way, but I haven't. I'm going to look into it before I fully try it, and then we'll see what we see. Are there like feelable benefits? Like, do you have like any sort of energy increase or?
I don't. Yeah, energy. Yeah. I would say yes.
You always have energy, though.
I'm like running on empty right now. I don't know what in the heck's going on. Not sleeping well. I'm on fumes. I was driving today. My eyes were closing on me, but that means you know what I need? I need some loaded gun coffee. Wake up to the bold flavors of Loaded Gun Coffee, where passion, precision, and patriotism infuse every single sip. As a veteran-owned business, we ensure that each cup is steeped in pride and unwavering commitment. The roasters handpick the finest coffee beans from around the world and have mastered unique brewing methods. Their skilled farmers cultivate the coffee to embody the essence of duty and honor in every meticulously crafted blend. But it's more than just coffee. It's a family-enduring commitment to freedom, with military veterans tracing their legacy back to the Civil War, including Purple Heart recipients. Loaded Gun Coffee is a brewed testament of pride and honor. Dedicated to preserving the integrity and strength of our beloved nation, they proudly stand as fierce advocates for a secure border and a strong America, and they stay loaded. Stay loaded, Badlanders, with Loaded Gun Coffee. Visit badlandsmedia.tv/loaded and enter promo code Badlands for 10% off your purchase. That's badlandsmedia.tv/loaded, promo code Badlands. All right, Ash rocking out the hat there. Yeah. So, all right, before we get into it, I know you had promised a quick update on the Coomer Lindell trial. So,
yeah, so I think, if it changed within the last hour, but the last update that I had, Coomer was still on direct examination. So basically what we talked about this morning, they did opening statements, and then the direct exam, the Eric Coomer testimony is going to probably run into tomorrow, because as of an hour ago, they hadn't even started cross yet on him. I heard he cried on the stand, and that's mostly what I know about that. But there's a cup that's about what happened in court today, except there is a rumor that there might be a change to the media order, that the coverage has come up a couple different times today in court, and it can't be my fault because I'm not there. But that it's potentially, can you imagine if there was a media blackout on this thing?
There better not be. I mean,
yeah,
there already is a media blackout because it's federal court. But in terms of like what we can remember and the notes we can take and get out to the public, this is a massive public interest case right here. I mean, not only is it a defamation case against America's beloved pillow maker, but it's also got huge election implications. So I sure hope that isn't the case, because
Yeah.
as I posted and you say all the time, democracy dies in darkness.
Yeah, I also I've tried to get real-time trial transcripts, and unfortunately they weren't ordered in the case, so there are no real-time trial transcript, which would have made covering it a hell of a lot easier. But
Of course.
yeah, it's strange, and I hope that's not the case. It's just a rumor. It's not there is no updated media order as far as I've seen. But I know several people that are in the court today, and there's definitely a outsized focus on media coverage.
Hmm. There is
All going one way, of course. And then, there's two briefs filed today by Eric Coomer's attorneys. This is the first one. It's a motion to seal these exhibits, the portions of the trial transcript that refer to these exhibits and the testimony of them, and then both the exhibits themselves and the portions of the trial transcript that reference any of these exhibits or discuss what's in them, that will all be sealed both in the trial itself. So they'll clear the courtroom when this stuff is being presented. Nobody except the jury and the parties and the attorneys in the court. And then in the post-trial motions as well, all of it will be sealed. So we will never get to know. The one that's weird to me is number 33.
Yeah. K2 Intelligence, I looked them up. It looks like they're kind of like they determine what the damages are, I think.
So it's an email string regarding a referral from K2 Intelligence.
Yeah, and it is interesting. You see the word intelligence and automatically people's minds start racing.
Well, didn't Jonathan Cagle Decentfy JC? I think he did a number of threads on K2 Intelligence as a intelligence community entity. But I thought that was interesting. I hadn't seen K2 Intelligence pop up in over a year. I hadn't seen that entity referenced. So that's interesting to me. And then just side note, in the Diddy trial, it came out that Mike Myers is CIA.
What?
Yeah. Dom Lucre had that today, and Grok confirmed it, but was like, there's nothing to suggest that he's still a part of the CIA. Well,
Please.
that shit's Hotel California. So
yeah.
I don't think you can be former. I don't really think that's a thing.
There are a couple things on here that are concerning for me. The confidential settlement between Coomer and Newsmax. The separation agreement with Dominion is a big one. The plaintiff's resignation letter and employee file are two big ones, as well as the settlement demands. The Dr. Finkel stuff, I'm okay with that because that's his therapist, and that's privileged medical stuff. So I mean, it is what it is. And
settlement stuff usually is as well. Your communications and negotiations in the settlement process are usually considered attorney-client privilege or legally privileged information. But that part's interesting. And then the second brief that they filed today is about Joe Altman and whether or not he should be allowed to assert reporter's privilege when asked questions, two specific questions. Who was it that got him on the so-called Antifa call? And I forget what the second question is. I can look it up real quick. But that was an interesting brief. You can see pretty clearly what their arguments are in it. Hold for processing.
I thought that didn't occur, the phone call. So why do they need to know?
Well, they're trying to prove that it didn't.
I know.
But you can't prove a negative. And so what they're trying to prove is that it's probably false. That's a legal standard, probable falsity. And two courts have already ruled, I believe, probable falsity, and it's the matter is currently in appeal. So this came up yesterday, saying that some of the stuff related to this shouldn't come up because the matter is still in appeal. Joe Altman's, I think what they wanted to bring in was that he was being fined $1,000 a day. And they're saying that they wanted the jury to see that. And the defense said, this is on appeal. Let's say it's overturned on appeal, then this jury has been tainted by it. And that was kind of arguments that were made yesterday. I think that's in my thread. But anticipating that he's going to assert legal privilege, they have filed this brief. And I'm just looking for the two specific questions. Hold.
Wouldn't it be something if his source came out and he's like, hey, yeah, just go ahead and throw my name out there. I don't care. It's probably intelligence.
Well, that was interesting because they quote him in here. Here, let me find that first. They quote Joe Altman as saying, and I have no idea where the statement is. It says, it was, they cited it. It's live with Clay Clark, monkeypox, primary elections, aftermath, war on babies, and Second Amendment surges, conservative daily podcast, August 3rd, 2022. And the quote is, this is Joe Altman speaking, they're trying to hone in on the Antifa call. Number one, I have an ace in the deal because at some point I'm going to come forward with that guy. I'm going to. I'm just telling you right now, I'm going to, and it's going to get really bad. It's going to get really bad because at that point, the rest of their argument falls apart. And then all the money they've spent on this lawfare, we get all of our money back. I'm just telling you, end quote. And they say he has publicly discussed his willful withholding of this information until he determines that revealing it will present a strategic litigation advantage for him. So that's Coomer, right? So grain of salt, but it's Coomer's and his attorneys quoting Joe allegedly in August of 2022 saying that he's going to bring forward the guy that got him like the Antifa, the person that got him on the Antifa call, the alleged Antifa call is a material witness because they can corroborate that it happened. Right now, there's nothing else except for Joe's contemporaneous notes that corroborate that it's happening. They're trying to prove that it didn't. But again, you can't prove the negative. So they're trying to prove, they want the judge to say probable falsity, that it's probably false. If they do that, then I think that Eric Coomer gets another bite at Joe Altman in terms of their ongoing litigation. And there's ongoing litigation there as well. So it'll be interesting to see if that witness is produced. Everybody wants that witness produced.
All right. Well,
yeah,
you ready to dive into this book?
Yeah, absolutely.
Let's do it. Are we reading the prologue?
I think we should.
All right. Well, I'll let you start then.
Okay. Let me get to the prologue.
For those following along.
Go ahead.
Prologue.
The dedication says, for the men and women whose experiences are recounted in these pages. I really enjoyed this book. And then the next has a quote. Those who won our independence by revolution were not cowards. They did not exalt order at the cost of liberty. And that's Justice Louis Brandeis. Is that right?
I don't know. I'm not on that.
All right. Prologue. But the plan, this is a quote, but the plans were on display. On display? I eventually had to go down to the cellar to find them. That's the display department. With a flashlight. Ah, well, the lights had probably gone. So had the stairs. But look, you found the notice, didn't you? Yes, said Arthur. Yes, I did. It was on display at the bottom of a locked filing cabinet stuck in a disused lavatory with a sign on the door saying, beware of the leopard. Douglas Adams, The Hitchhiker's Guide to the Galaxy. About a year before it moved across the street into its own building, the Supreme Court gathered, as it had for more than 7 decades, to hear the argument in the old Senate chamber in the Capitol. There, the justices confronted a curious problem. Is there any official or general publication of these executive orders? Justice Louis Brandeis said asked the government lawyer at the podium. Not that I know of, the attorney replied. The hearing that day concerned charges against 2 firms, Government officials alleged that the companies were busy producing more oil from fields in East Texas than a federal quota allowed. The only trouble was no one could seem to lay hands on the executive order containing the production quota that the companies had supposedly flouted. Well, is there any way by which one can find out what these what is in these executive orders when they're issued? The justice pressed. I think it would be rather difficult, the government lawyer answered. When his turn at the podium came, one of the company's lawyers, a portly red-haired man with a frontier manner of speech, told the court that the only set of rules he had ever seen had come from the hip pocket of an agent sent down to Texas from Washington. Newspapers reported that even the normally staid Chief Justice, Charles Evans Hughes, couldn't help but crack a smile. Other justices enjoyed a good-natured chuckle. Later, the government's lawyer told Congress that his staff had looked everywhere. They had found plenty of rules governing the company's activities, but they never did get to see the original of the executive order at issue. The best anyone could muster was a copy, and it turned out to contain no production quota at all. As the court wrote in its judgment, it appeared that the case against the two companies had proceeded through the entire judicial system upon a false premise, a government mandate which did not exist. I used to think the hip pocket incident a quirk of history. For some time, federal officials had resisted publishing their regulations for the public, arguing that the government wasn't in the newspaper business. But Justice Brandeis had long urged more transparency, and some say his questions at oral arguments sealed the deal. Soon afterward, the government agreed to create the Federal Register and publish there every new regulation it produced. Fast forward about 80 years. I was sitting as a judge in the Federal Court of Appeals in Denver. The federal government had accused a Kansas home health care company called Caring Hearts of fraud. Never a light matter, a charge like that threatened the firm's future. For 6 years, the dispute had dragged through the layers of administrative and judicial appeals. By the time it made its way to my court, Caring Hearts had lost it at just about every turn. But as my colleagues and I dug into the case, we could hardly believe what we found. Yes, Caring Hearts' conduct defied current published regulations, but the company had followed the rules in place at the time it had acted. Quite simply, Caring Hearts stood accused of breaking rules that hadn't yet existed. How could a case like that carry on so long and make it so far? It turned out that the government produces such a large number of rules at such a furious clip and with such complexity that even the agency officials responsible for them had become confused. I think it was then that the idea for this book began to take hold in my mind. It wasn't just that I had experienced my own version of the hip pocket incident. The episode led me to reflect on my years as a judge and realize that I had seen so many cases where the sheer volume and complexity of our laws had swallowed up ordinary people. The pattern repeated itself in the years that followed. The man who is told he can't see the evidence officials are relying on to reject his application for Social Security benefits. A veteran who is denied disability benefits because he fails to apply quickly enough for the taste of the Department of Veterans Affairs, even when Congress has instructed the agency to accept applications like his as timely. The immigrant who follows the law and is still refused a place in this country because the government changes the rules of the game on him retroactively. I could go on. As cases like these passed through my courtroom, I found myself thinking back to a speech that Václav Havel, the first democratically elected president of Czechoslovakia, gave as a dissident in 1965. More than 2 decades before the fall of the Berlin Wall, the country was in a grip of communist rule. At that time, Havel had observed that Prague was experiencing a rash of peculiar events. Window ledges from old buildings kept falling on people's heads. Often, after those episodes, some official or media personality would publish an article observing that, while of course no one wants plaster plummeting on people, readers should focus on the larger question facing mankind and marvel at the progress of their society as a whole. Articles like these, Hovell remarked, were the product of the purest of intentions, but they also contained a false logic, one that separated thought from any contact with the reality of ordinary people and their lived experiences. Prague's window ledges struck me as a kind of metaphor for what is happening in our law. Often, men and women going about their lives with no intention of harming anyone are getting thwacked unexpectedly and at times haphazardly by our multitude of statutes, rules, regulations, orders, edicts, and decrees. Almost always, one authority or another replies that while the impact on the individual at hand is most regrettable, we should really focus on the greater good our laws and regulations seek to achieve and the collective social progress they promise. But what do events and responses like these tell us about the health of our legal edifice? Before putting pen to paper, I wanted to spend some time studying in more depth the trends in our law that I saw playing out in individual cases. By the end of that process, I came to appreciate that just during my lifetime, our laws and regulations have exploded in number and have come to reach much more deeply into our daily lives. None of our institutions is immune from this development. Law has proliferated at the local, state, and federal levels alike. Much of it now comes from administrative sources, largely unresponsive to democratic elections, but plenty also comes directly from our elected representatives. Others have written about the economic costs that come with so much law, but my thoughts ran in a different direction. Those who can afford sophisticated lawyers may be able to muddle through. Those armed with influential lobbyists may even find ways to make a profusion of laws work to their advantage. But what about everyday Americans and the rights promised to them in our Declaration of Independence, Constitution, and Bill of Rights? What happens to those people and their foundational freedoms, like the right to speak, pray, and gather freely, when our laws increasingly restrict what we may say, monitor what we do, and tell us how we may live? What does it mean for our nation's promise of equal treatment when our laws become so numerous and so complex that only an affluent or connected few can navigate their way? And what happens to our respect for law itself when the law no longer just reflects common sense norms, but includes unpredictable traps for the unwary? Those are the questions I wanted to explore and invite you to consider as this book unfolds. This isn't an academic work or a legal brief. This is a book of stories. Stories about real people, their struggles to make their way in a world awash with law, and the toll on their lives and families. You will not meet lawyers in these pages, but fishermen and foster parents, an Amish community, hair braiders and monks, even a magician and the polydactyl descendants of Ernest Hemingway's cat. Why stories? Throughout history, we have understood one another and the world around us through stories. Our nation's founding values, too, center on individuals and their inalienable rights. Our government and laws were meant to serve them, not the other way around. So it is on individuals and their lived experiences that this book focuses. No one group, party, or impulse is to blame for the recent changes in our nation's approach to law. These days, we are a people who trust one another less and less. When a problem arises, we are no longer so inclined to rely on individual judgment, our neighbors, or our local institutions to address it. When an idea becomes popular, it seems our first impulse is to embody it in law and debut the new rule on a national stage. In our eagerness for quick solutions, we sometimes look to agency officials rather than our elected representatives. Sometimes, too, we do so with a demand for strict conformity and little effort to accommodate different views. All of these impulses have become deeply entrenched in our society, and they are developments thoughtful people of any stripe can appreciate, hold serious. Hold serious consequences for the integrity of our law and the lives and liberties of every American. Really, the questions at the heart of this book are ancient ones. At the dawn of our republic, James Madison contemplated the dangers to individual freedom, equal treatment of persons, and respect for law itself when a nation's laws are allowed to grow, quote, so voluminous that they cannot be read, or so incoherent that they cannot be understood, or undergo such incessant changes that no man who knows what the law is today can guess what it will be tomorrow. But if the questions Madison posed are old ones, they also seem to me ones with special relevance to our times. When sitting down to write this introductory note, I couldn't help but laugh when I had another encounter with the leopard. The hip pocket incident is legal lore. At the time, it made national headlines. I had heard and read about it, but I wanted to see the oral argument transcript for myself. That, however, turned out to be more difficult than I imagined. After striking out in a search of various online databases, I tried the Supreme Court library. No luck there either. Even the Library of Congress didn't have a copy. In the end, I had to rely on old newspaper articles and accounts from scholars. Over the years, I've asked myself what I can do about the problem of too much law. Ultimately, I always circle back to the same answer: not much. As a judge, my job is to apply the law. I cannot change the underlying impulses that have led us as a society to regulate ever more, criminalize ever more, and punish ever more. The best I can do is share with you what I have seen from my unusual vantage in our legal system. Judges are not supposed to live isolated from society, but are encouraged to engage in a wide range of life's activities and contribute to the law, the legal system, and the administration of justice. Many of my colleagues and predecessors have done just that, offering thoughtful books on an array of topics. It is in that same spirit that I offer this book. But if any real and lasting change is possible, it will not come from judges like me. It will come from people like those whose stories are recounted here. As Havel witnessed during the fall of communism, many of the deepest changes in his own society came from unknown people who wanted no more than to be able to live with the truth, to play the music they enjoyed, to sing the songs that were relevant to their lives, and to live freely in dignity and partnership. They had been given every opportunity to adapt to the status quo, yet they decided on a different course. NMG.
All right. So laying the foundation there, we're overruled, too much law. And the law isn't the most concerning part for me. It's the rules that are more concerning, but just my take.
Well, it's both. I mean, the law authorizes the regulatory in a lot of cases. There's also laws that just assume that the bureaucratic entities will create the regulations and everybody will just abide by them, and it doesn't actually have to be enshrined in law. But with Chevron, we have an opportunity to go a different direction. But it is we'll get into, as you get, I think the first couple chapters are just absolutely fire for setting the stage. I have so many flags on the first couple chapters of the book because it's overwhelming, and the facts that Gorsuch puts in here are the stuff of jokes, right? Lawyers' jokes and government jokes and whatnot. And actually, the best jokes are grounded in truth. So,
yep. All right. Chapter 1, an introduction to law's empire. The worse the society, the more law there will be. In hell, there will be nothing but law. Grant Gilmore. Fish and felonies. Early one morning in 2010, Sandra Yates was doing laundry when she noticed something alarming. 7 agents in bulletproof vests, hands primed on holstered guns, were approaching her bungalow in Anna Maria Island, Florida. It turned out they were looking for her husband. He's out crabbing, she told them, mystified by what they could want with John, a 58-year-old commercial fisherman who had worked his way up from a deckhand to captain of his own small crew. Sandra and John met as teenagers 36 years earlier in Ohio. John's father owned a bait shop, and together father and son spent many weekends fishing on Lake Erie. As Sandra put it, John more or less grew up on the water. The couple married, had a child, and moved to Florida to follow family and stake out a new life. John got a job doing what he loved most, fishing, while Sandra worked as a paralegal. By the time the agents showed up, the couple had lived in Florida for more than 28 years. Should we do like the...
Yeah, there's a picture of them.
Like in school? Okay. When Sandra called John to let him know that the officers were looking for him, he was just as confused as she was. After all, he had nearly blemish-free record as a fisherman, and he couldn't remember having done anything that might interest the authorities. John remained just as confused when he returned to shore and agents handcuffed and transported him 2 hours away to Fort Myers for booking. There, John finally learned the charges against him. Among other things, he stood accused of violating the federal Sarbanes-Oxley Act, known as SOX, and faced a potential term of 20 years in prison. Now, you might be wondering, Sarbanes-Oxley? Isn't that some sort of law about financial crimes?
Yes, yes, it is.
Yeah. Does this book predate J6?
Um,
I think it was written after that.
Let's see. And,
Copyright 2024. So yeah, it predates it, or it postdates it. It's after.
It's after, yeah.
If you poke around the internet, as Sandra did late into the night in the days after her husband's arrest, you will find the act described as designed, quote, to help protect investors from fraudulent financial reporting by corporations, end quote. You will also learn that Congress adopted the law in the wake of a financial scandal that brought down the accounting firm Arthur Andersen. Some say the firm engaged in a document shredding frenzy after being tipped off about an impending federal investigation into work it had performed for its client, Enron. All that might lead you to ask, what does any of this have to do with a small-time fisherman? The story starts back in 2007. One day, while John was fishing in the Gulf of Mexico, Gulf of America, on his boat, the Miss Katie, a state wildlife agent cross-deputized.
This predates that change, though.
I don't care. If they can change the law retroactively, I can change the name of the Gulf of America.
You can change Gorsuch's book retroactively.
Exactly. A state wildlife agent cross-deputized by federal authorities, always a red flag, by the way, and I hate the idea of that, came alongside. As John tells it, the agent boarded the boat for a safety inspection and then asked John to open up the fish hold. The agent said he wanted to measure the fish, all 2,000 pounds of them. After spending hours rummaging through the pile, the agent declared his verdict. According to his measurements, which John disputed, 72 red grouper were under the 20-inch harvesting minimum set by then current federal regulations. True, even by the agent's count, only 3 fish were under 19 inches, and each was at least 18.75 inches. But all the same, 72 undersized fish it was. The agent ordered John to store the undersized fish in separate crates, issued a citation, and left. After John returned to the dock a few days later, the agent measured the fish again. This time, though, the agent found 69 undersized fish, not 72. What's more, the agent's measurements didn't quite match what he had taken days earlier on board. From that and other evidence, the agent grew suspicious that the fish at the dock were not the same fish he had measured at sea. Dun, dun, dun. Still, nothing seemed to come of it. John didn't hear anything more from the authorities for almost 3 years. That is, until the day armed agents showed up at his home, at his front door, excuse me. At this point, you still might be wondering what any of this has to do with the Sarbanes-Oxley Act. As John learned after his arrest, however, that law is written in broad terms. Mm-hmm. The act doesn't just make it unlawful to destroy financial records or documents, quote, with the intent to impede, obstruct, or influence a federal investigation. It also prohibits the destruction of any other tangible object for the same purpose. And according to the government, John had done just that.
Pause there for a second. So this is 2007 is when the boat incident happened. 2000, I think Sarbanes-Oxley was what, 2002, 2003? 02. Right. And so they passed this law to deal with Arthur Andersen and Enron. And it was, you can't destroy financial documents if you're being investigated, which, let's be honest, should have been a law before, but what are you going to do? The Sarbanes-Oxley Act was a massive sweeping piece of legislation. But the destruction of documents is the same, or the destruction of things, right? Evidence, during an investigation or during an official proceeding is also, as you mentioned, what the J6ers, a lot of them were charged with. Was it 201? Is that right?
1512.
1512. Thank you. I don't know what 201
C2.
was.
1512 C2.
Yeah. So they were so we start out with, hey, there's this financial crime thing. This audit firm, which is responsible for public trust, is cooking the books of a major corporation and then destroying evidence, shredding documents like crazy when they get caught. It's only 5 years later that the federal government is using that law to say that this guy destroyed fish. And because of that, this is the problem with the mindset of people in government. And then you fast forward. So that's 2002 to 2007. Fast forward to 2021, 2022, and going into a building and walking through is a violation of the Sarbanes-Oxley Act. It's mental. If you open the door to the government to come into your life, they will kick it open and bring all their friends.
Three felonies a day.
Mm-hmm.
3 felonies a day. The government's theory ran this way. John or a member of his crew must have thrown overboard the undersized fish the agent had identified while out on the water. Before returning to port, the crew must have then replaced those fish with new and still undersized substitutes from their remaining catch. On the basis of this theory, the government argued John had destroyed tangible objects, yes, fish, with the intent of impeding a federal investigation. Needless to say, John saw things differently. On his account, it was hardly surprising that the agent's 2 sets of measurements didn't quite align. Fish expand and contract when they are moved into and out of cold storage and onto hot decks or docks. According to John, the agent wasn't exactly a fish measuring expert either. Among other things, he didn't properly account for the lengthy lower jaws of red grouper. To this day, John considers the government's theory that that he threw the undersized fish overboard only to replace them with new, still undersized substitutes, quote, about the stupidest thing I've ever heard. Stupid or not, it turned John and Sandra's lives upside down. On top of facing prison time, John lost his job. No one would hire a potential felon out of favor with the federal government. He was contaminated, as Sandra put it. The couple lost their principal source of income and soon their house. God, I hate these people.
Yeah.
They stopped taking family vacations with the grandchildren. They were busy raising and tried to make ends meet by opening a used furniture store called Off the Hook Cortez. John refurbished furniture and Sandra painted it. To prepare for trial, Sandra stayed up late into the night researching the law and corresponding with attorneys and agency officials. It was tough going. The family's ordeal was not made any easier knowing that federal officials had recently revised their regulations. When the agent boarded John's boat in 2007, the minimum harvesting size for red grouper was 20 inches. But by the time John was arrested 3 years later, that had changed. The new rule, 18 inches. Even by the lights of the agent's measurements, not a single one of John's fish was that small.
Hang on a second. If that kind of change swung in favor of the government, they would say, well, this is moot now. Yep. But because it swung, or, if they were being accused and it swung, because it swung against the person that they were accusing. And I think, my personal opinion, now this is the 3rd time I've read this, my personal opinion is that they were seeing how they could expand the law, seeing if they could use that statute to apply to other things, which they do a lot over lots of different domains of our lives, because it was against an individual and not a government entity. It's not moot. You're still in trouble because that was the law at the time. And we're talking about fish that like they'll when they dry out, they're going to shrink.
Yep.
Like it's so ridiculous. It is one of the stupidest things I've ever heard.
Still, the government pressed ahead with its case. In time, prosecutors offered a plea deal that would allow John to plead guilty to an offense involving the forcible opposition of a federal officer. But John saw no basis for that charge. He wanted to clear his name and insisted on standing trial. It did not go well. Over a year after his arrest and 4 years after the agent boarded his boat, and a jury found John guilty of the Sarbanes-Oxley offense. At sentencing, the court imposed a term of 30 days behind bars. Prosecutors had asked for closer to 2 years. The court also sentenced John to 3 years of supervised release, ordering him to submit a DNA sample and subjected him to other restrictions. The prosecution team insisted a press release touting its victory. By now, what's that?
Prosecution team issued.
Oh, my bad. By now, it was nearing Christmas 2011. John sought permission to report to prison after the holiday so he could spend time with his grandchildren, 8 and 12 years old at the time. The request was denied. So John sat in prison over Christmas. What more, at age 59, he was required to wear an ankle bracelet marking him as an escape risk. After serving his sentence, John was ready to move on. The case had consumed his family for too long, but Sandra was determined to appeal. She didn't want government officials to do to someone else what they did to us. Even when their appeal failed, Sandra wouldn't give up. She persuaded John and his attorney, today a federal judge, to petition the Supreme Court to review John's Sarbanes-Oxley conviction. It was the longest of long shots. The Supreme Court agrees to hear only about 1% of the thousands of petitions it receives every year. But 7 years after that agent boarded the Miss Katie, John and Sandra finally saw a sliver of hope. In 2014, the court announced it would hear their case.
It is the violation of the Sarbanes-Oxley Act is that the agent felt that they were different fish and said, well, the measurements didn't match and it feels like they're different fish. And
wouldn't the burden be on them to prove that?
Yeah, it should. And also their theory of the case is that he replaced the fish, but with different fish that were still a violation. There's actually no upside to that. Like, why would he do that? What's the mens rea? What's the criminal mind of that act? I really do believe they were just they found a case where they could test this Sarbanes-Oxley thing with things other than documents, with things other than financial records. Let's get out into the things of value in the real world and see if we can make this stuff stick. And it worked for a while, ruin these people's lives, but they don't care about that.
That's a great point. I mean, that literally shows ill will and malice in their intentions to do that to somebody. And I can't tell you enough. You guys, for those of you that saw Gart, was it Plymouth, when we did the 10th Amendment panel, Ash, I had not yet read this book, and I decided on the flight to Massachusetts to start reading it. And I texted Ash right away, and I was like, you son of a, why did you make me read this? Because it's so good, but it's so infuriating. Yeah,
there's lots of this. As he said in the prologue, this book is full of stories, and most of them are going to piss you off.
Yep.
And he does kind of give, like Cash does in Government Gangsters, there is kind of a playbook. It's not as direct and explicit, but you do kind of see the light and the pathway out of this madness. But yeah, you're going to get real pissed first.
All right.
A Nation of Laws. More on the Yates family in a moment. First, let's take a step back. John's story might seem unusual, but is it? Maybe you've heard about the 6-year-old who landed in court for picking a tulip by the bus stop, or the 10-year-old whose lemonade stand was shuttered for lack of a business license, or any of the hundreds of similar cases. And all of these examples that he says are cited in the appendix, by the way.
Yep.
The truth is something's happening in our country. Law is multiplying and its demands are growing increasingly complex. So much so that ordinary people are often caught by surprise, and even seasoned lawyers, lawmakers, and yes, judges sometimes struggle to make sense of it all. Of course, our country has always been a nation of laws. As children, we learned about the Boston Tea Party and how colonists objected to unjust laws announced by a capricious king, and how our founders chafed at taxation without representation. But we sometimes forget that they demanded laws too. When the 13 colonies decided to part ways with Great Britain, they detailed their reasons in the Declaration of Independence. High on the colonists' list of grievances was King George III's refusal to assent to laws proposed by colonial assemblies. When it came time to draft the Constitution, the founders paid special attention to lawmaking as well. They didn't start by addressing how to elect our president or who would lead the troops into battle in times of war. They didn't even begin by recording the freedoms we treasure, like the right to be free from unreasonable searches, to speak freely, and to live out our religious beliefs in peace. Instead, in Article 1, they established Congress and proceeded to outline detailed procedures for how our national government was to make new laws. In some respects, nothing about this was a given. Plenty of other nations did and continue to do it differently. Like the colonies, France rebelled against a king in the 18th century. That country went through 8 constitutions in the span of 24 years. The first began with a list.
Which, by the way, is more in line with Jefferson's intentions. I'll just throw that out there. Than what we're doing now.
The first began with a list of certain guaranteed rights and then moved on to various matters of citizenship. Only in Title III did it discuss legislative powers. Today, Canada's Constitution begins with a discussion of executive authority and doesn't get to the principal powers of lawmaking until Article 91. Russia's constitution doesn't address lawmaking until around Article 94. In other respects, though, our Constitution's special focus on lawmaking makes perfect sense. As the political theorist Hannah Arendt put it, law is much more important in this country than in any other because Americans are, quote, united neither by heritage nor by memory, nor by soil, nor by language, nor by the same place of origin. What unites us is a common commitment to self-governance under a constitution the people themselves have approved. In America, as Thomas Paine wrote, only the law is king. We take rightful pride in this heritage. As middle school students, we learn about the founders' vision that a free and diverse people can rule themselves wisely through laws produced by their elected representatives. As adults, we cherish these ideals and count on them to order our daily lives. So what happened? How did we get here? How can a fisherman face the possibility of decades in federal prison under the Sarbanes-Oxley Act for allegedly throwing fish overboard, and not one of the dozens of officials who touches this case says, wait a minute? How can that same fisherman then go on to lose his livelihood and lose his case before a jury and then again before an appellate court? And how can it be that his story isn't an uncommon one today?
God, that'd be a hell of a, I know where Anna Maria Island is. That would be a hell of a story, sitting in the bar in a, a little seaside town like that. And, I'm broke. Can you buy me a beer? Why are you broke? Because I've been fighting the federal government over what? Throwing some fish back, allegedly.
Yeah.
It's just
fish that the numbers didn't make sense to begin with. It was 72 fish, but only 3 of them were allegedly undersized. And when you then look at the statute, by the time this thing went to trial, the law had already changed to be 18 inches instead of 20, and it didn't matter. It didn't matter because it's equal justice under the law is bullshit. If it swings in favor of the government or the bureaucratic entity, then they always get the presumption of good faith and the benefit of the doubt. But if it swings in the direction of a regular citizen, they're going to throw the book at you unless you're connected. That's my opinion.
Yep. A paper blizzard. At the most basic level, law in our country has simply exploded. Think Congress is racked by an inability to pass legislation? Less than 100 years ago, all of the federal government's statutes fit into a single volume. By 2018, the U.S. Code encompassed 54 volumes and approximately 60,000 pages. Over the last decade, Congress has adopted an average of 344 new pieces of legislation each session. That amounts to about 2 to 3 million words of new federal law each year. Even the length of bills has grown from an average of around 2 pages in the 1950s to 18 pages today. That's just the average. Nowadays, it's not unusual for new laws to span hundreds of pages. The No Child Left Behind Act of 2001 ran more than 600 pages. The Patient Protection and Affordable Care Act, almost 1,000 pages. And the Consolidated Appropriations Act of 2021, which included a COVID-19 relief package, more than 5,000 pages. About the last one, the chairman of the House Rules Committee quipped that, quote, if we provided everyone a paper copy, we would have to destroy an entire forest, end quote. Buried in the bill were provisions for horse racing, approvals for 2 new Smithsonian museums, and a section on foreign policy regarding Tibet. By comparison, the landmark protection afforded by the Civil Rights Act of 1964 took 28 pages to describe. Still, these figures from Congress only begin to tell the story. Federal agencies have been busy too. They write new rules and regulations implementing or interpreting Congress's laws. Many bear the force of law. Thanks in part to Justice Brandeis, agencies now publish their proposals and final rules in the Federal Register. Their final regulations can also be found in the Code of Federal Regulations. When the Federal Register started in 1936, it was 16 pages long. In recent years, that publication has grown by an average of more than 70,000 pages annually. I'm going to read that again. When the Federal Register started in 1936, it was 16 pages. In recent years, that publication has grown by an average of more than 70,000 pages per year. Meanwhile, by 2021, the Code of Federal Regulations spanned about 200 volumes and over 188,000 pages. How long would it take a person to read all those federal regulations? Some estimate, quote, over 3 years. And that is just the reading component, not comprehension, not analysis. Even those numbers do not come close to capturing all of the federal government's activity. Today, agencies don't just promulgate rules and regulations. They also issue informal guidance documents that ostensibly clarify existing regulations, but in practice often, quote, carry the implicit threat of enforcement action if the regulated public does not comply, end quote. In a recent 10-year span, federal agencies issued about 13,000 guidance documents. Sometimes these documents appear in the Federal Register. Sometimes they don't. Sometimes they are hard to find anywhere. Echoing Justice Brandeis's efforts, a few years ago, the Office of Management and Budget asked agencies to make their guidance available in searchable online databases. But some agencies resisted. Why? By some accounts, they simply had no idea where to find all their own guidance. Ultimately, officials abandoned the idea.
And read that again. And it is Brandeis. I looked it up.
Okay. But some agencies resisted. Why? By some accounts, they simply had no idea where to find all of their own guidance. Ultimately, officials abandoned the idea.
So it would be too hard for them to pull together an actual register because the agencies themselves can't even find all of their regulations. So rather than deal with that problem, they just abandon the effort. I hate these people.
I so hate these people. Judicial decisions as well contain vital information about how all of our laws and rules operate. Today, most of these decisions can be found on searchable electronic databases, but some come with high subscription fees. If you can't afford those, you may have to consult a library. Good luck finding what you need there. Reported federal decisions now fill more than 5,000 volumes. Each volume clocks in at about 1,000 pages, for a total of more than 5 million pages. Back in 1997, Thomas Baker, a law professor, found that, quote, the cumulative output of all the lower federal courts amounts to a small but respectable library that, when stacked end to end, runs for 1 1/2 football fields. One can only wonder how many football fields we're up to now. As you might imagine, much in this growing mountain of law isn't exactly intuitive either. Did you know that it's a federal crime to enter a post office while intoxicated? Actually, I did. Or to sell.
Why did you get in trouble for it?
No, but there may or may not have been a
drunken postal.
Not me, but I know a friend that got a fine for that. Or to sell a mattress without a warning label.
That one I thought was removing the label from a mattress.
It can't be removed from the manufacturer or the seller. It can be. You can actually remove your mattress labels.
But you know why that sticks in my brain?
Because it's so stupid.
Well, yes. Also, because it was in Pee-wee's Big Adventure, the Pee Wee Herman movie.
Oh, yeah.
Yeah. When he meets, he's like, what'd you do? And the guy's like, I removed the label off the mattress. That's stuck in my brain forever. It's still there.
And if you're a budding pasta entrepreneur, take note. By federal decree, macaroni must have a diameter between 0.11 and 0.27 inches, while vermicelli must not be more than 0.06 inches in diameter. Both may contain egg whites, but those egg whites cannot constitute more than 2% of the weight of the finished product.
That's so stupid.
I fucking hate
it. Because there is not that now to have that law, that means you have the regulatory and enforcement apparatuses. You have the pasta police in the FDA, which has an allowable amount of maggots for your food.
This is why I wanted the Connie Francis song for the intro.
Yeah, you can change it back if you want.
No, it's okay. The Clash fit. It was actually the perfect length, so it was the easiest thing to switch them out.
Sorry, YouTube. You guys didn't see it, but if you check it out on Rumble, you can see the intro to our show.
Yeah, I had to cut it because on YouTube, I had to cut it because there's If officials in the federal government have been busy, it's not as if their counterparts at the state and local levels have been idle. Virginia prohibits hunting a bear with the assistance of dogs on Sundays. In Massachusetts, be careful not to sing or render the Star-Spangled Banner as part of a medley of any kind. That can invite a fine. Meanwhile, in New York City, administrative code spans more than 30 titles, and the rules of the city of New York more than 50. In 2010, the New York Times reported on the regulatory hurdles associated with opening a new restaurant in the city. It found that an individual, quote, may have to contend with as many as 11 city agencies, often with conflicting requirements, secure 30 permits, registrations, licenses, and certificates, and pass 23 inspections. And that's not even counting what it takes to secure a liquor license. We learned about a lot of that in Art of the Deal, and that was in the 80s, 70s, and 80s there.
Yeah.
To appreciate the growth of our law at all levels, consider the lawyers. In recent years, the legal profession has proven a booming business. Between 1900 and 2021, the number of lawyers in the United States grew by 1,060%, while the population grew by about a third of that rate. Since 1950, the number of law schools approved by the American Bar Association has nearly doubled. The number of lawyers in Washington, D.C., that stands at about 1 for every 25 residents. With the growth of law and its complexity, lawyers' salaries have had no trouble keeping pace either. Equity partners in some of the nation's largest law firms now make on average over $1 million a year. Demand for legal services is so great that most Americans today cannot afford even desperately needed legal advice. Our legal institutions have become so complicated and so numerous that even federal agencies cannot agree on how many federal agencies exist. That's fucking insane.
Not even that's not how many rules, how many regulations. That's how many agencies.
Yeah. A few years ago, an opinion writer in Forbes pointed out that the Administrative Conference of the United States lists 115 agencies in the appendix of the source book of the United States Executive Agencies. But the publication also cautions that there is, quote, no authoritative list of government agencies. Meanwhile, the United States Government Manual and USA.gov maintain different and competing lists. And both of these lists in turn from the list, and both of these lists differ in turn from the list kept by the Federal Register. The last publication appears to peg the number of federal agencies at 436.
It's quite the disparity.
Right? Reflecting on these developments sometimes reminds us of Parkinson's Law. In 1955, a noted historian, C. Northcote Parkinson, posited that the number of employees in a bureaucracy rises about 5% per year, quote, irrespective of any variation in the amount of work, if any, to be done. He based this amusing theory on the example of the British Royal Navy, where the number of administrative officers on land grew by 78% between 1914 and 1928, during which time the number of Navy ships fell by 67%. And the number of Navy officers and seamen dropped by 31%. It seemed to Parkinson that in the decades after World War I, Britain had created a, quote, magnificent navy on land. He also quipped that the number of officials would have multiplied at the same rate had there been no actual seamen at all.
That's what she said.
Does Parkinson's Law reflect our own nation's experience? In the 1930s, the Empire State Building, the tallest in the world at the time, took 410 days to build. A decade later, the Pentagon took 16 months. In the span of 8 years during the Great Depression, President Franklin D. Roosevelt's Work Progress Administration built some 4,000 new schools, 130 new hospitals, 29,000 new bridges, and 150 new airfields, laid 9,000 miles of storm drains and sewer lines, paved or repaired 280,000 miles of roads, and planted 24 million trees. Compare those feats to more recent ones. In 2022, an opinion piece in the Washington Post observed that it had taken Georgia almost $1 billion and 21 years, 14 of which were spent overcoming regulatory hurdles, to deepen a channel in the Savannah River for container ships. No great engineering challenge was involved. The 5-foot deepening project, quote, essentially required moving muck. Meanwhile, raising the roadway on a New Jersey bridge took 5 years, 20,000 pages of paperwork, and 47 permits from 19 agencies, even though the project used existing foundations. The same newspaper reported that in recent years, Congress had required more than 4,000 annual reports from 466 federal agencies and nonprofits. According to lawyer and author Philip K. Howard, one report on the printing operations of the Social Security Administration took 95 employees more than 4 months to complete. Among other things, it dutifully informed Congress of the age and serial number of a forklift.
Nobody's reading these reports.
Nobody.
Maybe there's one person in, the regulatory office that updates some other list with the information from the report, but 4,000 annual reports from 466 agencies, which are done at the request of the Congress. The Congress says, well, we're going to provide meaningful oversight, so you need to give us an annual report. 466 agencies, you need to give us a report, but nobody's reading those reports. In theory, they go to the committees that have oversight of the specific entities, and they'll go through and read the reports and provide some sort of something, but they're all too busy, holding fake government secret committees and being Instagram influencers to actually read the reports that they ordered. So what does that mean? There's a whole bunch of people out there that we're paying salaries to doing busy work to create reports that nobody's ever going to read.
It's an absolute joke.
Show me the man and I'll show you the crime. Not only have our laws grown rapidly in recent years, as we will see in the coming chapters, so have the punishments they carry. You might think that federal criminal laws are reserved for the worst of the worst, individuals who have committed acts so egregious that they merit not just the attention of state authorities, but federal authorities, and not just civil fines, but potential prison time. But if that's your intuition, start by asking yourself this question: how many federal crimes do you think we have these days? Turns out no one knows. Yes, every few years, some enterprising academic or government official sets out to count them. They devote considerable resources and time, often years, to the task. But in the end, they come up short every time. In 1982, the Department of Justice undertook what stands as maybe the most comprehensive count to date. A lawyer spent more than 2 years reading the U.S. Code, at that time, some 23,000 pages. At the end of it all, the best the lawyer could say was that there were about 3,000 federal crimes. A little more than 40 years later, the U.S. Code is roughly twice the length it was in 1982, and contemporary guesses put the number of federal crimes north of 5,000. As the American Bar Association has put it, whatever the exact number of crimes that comprise today's federal criminal law, it is clear that the amount of individual citizen behavior now potentially subject to federal criminal control has increased in astonishing proportions in the last few decades. Part of the reason no one can easily count the number of federal crimes is that our federal criminal code was not planned, it just grew. We do not have a single place in which people can turn to discern what our criminal laws prohibit. Sure, there's Title 18 of the U.S. Code. It's labeled Crimes and Criminal Procedure. But in truth, criminal laws are scattered here and there throughout various federal statutory titles and sections, the product of different pieces of legislation and different Congresses. Really, our federal criminal law is a loose assemblage of components that were built hastily to respond to perceptions of need and to perceptions of the popular will. That's not the only confounding factor, though. Many federal criminal statutes overlap entirely and are duplicative in part, or when juxtaposed, raising perplexing questions about what they mean. Take fraud. We have federal mail fraud law. We have federal wire fraud law.
Uh-oh. Lily Pad says I'm out.
Hold for processing. She won't shut up unless I let her out. So
Here, I can keep going.
Okay.
We also have federal law forbidding the deprivation of honest services, though no one is exactly sure what that does or does not add to all those other laws about fraud. On top of all this, more new laws criminalizing fraud are opposed in just about every session of Congress. Once more, too, Congress's output represents just the tip of the iceberg. Our administrative agencies don't just turn out rules with civil penalties attached to them. Every year, they generate more and more rules carrying criminal sanctions as well. How many? Here again, no one seems sure. but estimates suggest that at least 300,000 federal agency regulations carry criminal sanctions today. Good.
If you were to sit down to read through all of our criminal laws and regulations, or at least flip through them, you would find plenty of surprises too. You would learn, for example, that it's a federal crime to injure, to, quote, injure a government-owned lamp in Washington, D.C., consult with a known pirate, or advertise wine by suggesting its intoxicating qualities. The truth is, we now have so many federal criminal laws covering so many things that one scholar suggests that, quote, there is no one in the United States over the age of 18 who cannot be indicted for some federal crime. In case you think that's an exaggeration, he adds, that is not an exaggeration. It's a state of affairs that sometimes makes it hard not to wonder how far we have left to travel to a world described by Lavrenti Beria, the chief of Joseph Stalin's secret police, who was reputed to have bragged, "Show me the man and I'll show you the crime." Don't think it can happen here? Ask John Yates, who was convicted for an offense he probably never heard of, one that few would have imagined could apply to him, and one that robbed him and his family of the life they cherished.
Keep going.
Beyond the numbers. Numbers tell part of the story, but only a part. Today, the law touches our lives in very different ways than it once did. In the past, the rules that governed what happened in our homes, families, houses of worship, and schools were found less in law than in custom, or were left to private agreement and individual judgment. Even in the areas of life where law has long played a larger role in its character, its character has changed. Once, most of our law came from local and state authorities. Now, federal law often dominates. That's the supremacy clause, by the way. It's an exploitation of the supremacy clause. Later chapters explore these developments in more depth, but consider just a few examples here. In the past, a 7th grader who traded burps for laughs in class might have been sent to the principal's office. These days, law enforcement officers may make an arrest. A 24-year-old who downloads academic articles that don't belong to him isn't just reprimanded. Now we threaten him with decades in federal prison. On a more systemic scale, consider that for most of our history, responsibility for educating the young and setting public school policy rested almost completely in the hands of parents and local and state officials. Until 1979, the federal government didn't even have a cabinet-level Department of Education. Now, that federal agency employs more than 4,000 people and has an annual budget of almost $70 billion. Not for long. While it shares much of that money with states and local schools, it often does so on the condition that they comply with an ever-growing list of federal mandates. What's responsible for the changing character of our law? No doubt it's a complicated story, and we live in an increasingly complex world. But just consider what America looked like when Alexis de Tocqueville traveled the country in the 1830s. I love this part. Mm-hmm. As the historian Niall Ferguson observed, Tocqueville marveled at the way early Americans preferred voluntary association to government regulation. As Tocqueville himself recorded, not only do they have commercial and industrial associations, they also have 1,000 other kinds: religious, moral, grave, feudal, very general and very particular, immense and very small. Americans use associations to give fetes, to found seminaries, to build inns, to raise churches, and to distribute books, to create hospitals, prisons, and schools. In short, Tocqueville concluded, everywhere that at the head of a new undertaking you see the government in France and a great lord in England, count on it that you will perceive an association in the United States.
All right, hold on there for 1 second, because I want to go back to the Department of Education thing, because, obviously that's a big topic right now in the Trump administration, trying to dismantle it. Mm-hmm. But at the same time, if he wanted to go in there and change all the federal mandates that Gorsuch alludes to in the chapter right here, he can't even do that. And so, this is where we talk about these bureaucracies working as essentially a fourth branch in our government, because nobody has oversight over them. And you'll see within the first 3 chapters of this book how bad it really is.
Yeah, I just have to say, I love that exploration of association. Freedom of association is something that is almost forgotten in our country because everything is a 501 now, right? Every time people get together to do any sort of thing, they have to incorporate it and they have to establish it and they have to go to the government and say, we're doing this. Is that okay? Can you, give us the right tax status? And that's such a perversion of what America once was, and was envisioned to be at its founding. I love that. I saw that too. Well done, A. Fritz. And thanks to Snack Cakes 802 for gifting 5 subscriptions to Badlands Media. We appreciate you. The freedom of association was something that we actually had on trial in our case. And it was ironic because the NAACP is one of the entities that enshrined freedom of association as into the case law, as he talked about case law earlier on around the First Amendment. You have the freedom of association. You and other people can go and do stuff. And you don't have to ask the permission of the government to do it. If you're engaging in commerce and all those sorts of things, then that might be different. You might find, you might be under different statutes. But if you're getting together, like all of the things that he said, build inns and raise churches and distribute books, hospitals, prisons, all of those things, we abandoned that as a people and gave all of that what our way of life as Americans was pretty voluntarist. And this is something that, it comes up a lot when G Money and I argue, or Burning Bright and I argue, or like we should have a more voluntary society. I agree. And I think that really can work in the micro, but it's got to be a mindset, right? You have to have you have to have the freedom of association mindset. We set out best legal advice I ever got was from attorney Gary Fielder. And he said to me, never incorporate and just stand on your freedom of association. You don't have to beg the government to allow you and your friends to organize. You don't have to do that. Just stand on your freedom of association. And that was the argument that got USCIP dismissed in the case. The First Amendment is still in effect. We just have to have the mindset to remember it and to start acting like it.
Hell yeah.
These days, many of those old civic bonds are fraying. In his book, Bowling Alone, Robert Putnam reports that both civic engagement and organizational involvement experienced marked declines during the second half of the 20th century. In recent years, those declines have continued uninterrupted. A few decades ago, over 70% of Americans were members of a church, synagogue, or a mosque. Today, fewer than half are. The Elks, a fraternal order that boasts 6 presidents among its past members, has struggled in recent years with a massive decline in membership. The Freemasons have shed 3 million from their ranks since the 1950s, a 75% decline. Accompanying this decline in civic association, we have experienced a profound decline in trust with one another. We are less inclined to respect or even tolerate different ideas about how to live, raise children, and pray. Increasingly, studies show we consider those who disagree with our own political views to be immoral or unintelligent. In one recent survey, roughly half of surveyed voters expressed the view that individuals who support the other party pose a threat to the American way of life. About 40% said the use of violence may be warranted to prevent those who hold competing views from achieving their goals. Rather than trust individuals to judge what is best for their own happiness, health, and safety, we have become increasingly comfortable doing what the experts tell us, and increasingly comfortable with forcing others to do the same. It's hard not to wonder when the explosion in our laws owes at least something to these developments. After all, when trust in individual judgment, civic institutions, and social norms fades, where else is there to look for answers but the law? Perhaps, too, the law does more at the national level because it can. Communication across the continent has become a simple thing. So has the capacity to store and search vast amounts of information and monitor the movement of individuals, all of which allows authorities to direct and track compliance with their rules in ways that were unthinkable even a generation ago. Whatever the combination of causes, one thing seems clear. If in this country law has always been king, its empire has never been so vast. More than ever, we turn to the law to address any problem we perceive. More than ever, we are inclined to use national authorities to dictate a single answer for the whole country. More than ever, we are willing to criminalize conduct with which we disagree. And more than ever, if elected officials seem slow to act, we look to other sources of authority to fill the void.
Man, is that true?
Yeah.
Miracles do not cluster. The chapters that follow do not just trace these developments through the experiences of individuals like John and Sandra Yates. They also seek to explore what those developments mean for our lives and liberties and law itself. But as a starting point, consider what those who wrote our Declaration of Independence and Constitution hoped for. One of the essential purposes of our founding documents, Justice William O. Douglas famously wrote, quote, was to take government off the backs of people and keep it off. Historically, after all, Americans have cherished the right to form their own opinions, speak their own minds freely, and worship, or not, without interference. We like to think of our homes as our castles, generally subject to invasion only with a lawful warrant. We take for granted that authorities cannot deny our freedom without the assent of an impartial jury and due process. At least initially, though, our Constitution didn't mention many of these rights. Most found expression only later in the Bill of Rights. James Madison was instrumental in drafting both documents, but he harbored some skepticism about the second. As he saw it, any liberties the federal government might promise in a Bill of Rights would only ever be just that, promises. The most effective way to protect our liberties, he thought, wasn't by recording them on a piece of parchment. It was by devising a system of government calculated to respect them. Madison's study of history persuaded him that people are naturally ambitious and tend to seek power over not just their own lives, but others. That fact of human nature, he believed, meant that the only sure way to protect our individual rights and keep government off the backs of people was to pit ambition against ambition. To that end, the Constitution Madison helped draft divided governmental powers both vertically and horizontally. It did so vertically by leaving most lawmaking power in the hands of state and local authorities, those closest to the people, a division of power called federalism. To the central government and remote capital, the Constitution afforded only certain limited and enumerated powers. The powers over foreign affairs, for example, along with other matters of a distinctly national character. Within the central government, Madison proceeded to divide power horizontally among three branches: legislative, executive, and judicial. Even within those branches, he checked and balanced power still further, nowhere more notably than when it came to the business of making law. As our Constitution envisioned it, any new law would have to win approval from two separate houses of Congress, composed of elected representatives chosen by different constituencies for different terms. Even then, a new law would have to earn the president's approval or sufficient congressional support to override a veto.
Hang on a second.
Yep.
Power of the political parties right here. That method of government that Madison designed, that the founders designed, is, neutered by the political parties. And the founders warned of political parties. There are these especially in Washington, and we see it show up at the state level as well. They're working on a different incentive structure, and that incentive structure has to do with the power within the system that they're really not supposed to even have.
If you haven't read George Washington's farewell address, it's like that might even be worth like something to like read on one of the shows one day.
Yeah.
Especially towards
I
the
like you
end.
kind of find a cool video of it being read and play it as an
Yeah, there's a
outro.
couple, and it's really difficult to understand because it's a different form of English. So there's actually videos out there that read it in a common meaning reading, although it's best to read it Washington's
No, it's
way.
like the Message Washington.
Yeah, it's like telephone
Message
Washington.
Bible.
It's like playing a game of telephone. Making new law was supposed to be a difficult business, as Madison saw it. By requiring such a long and deliberative process, one so dependent on consensus, the Constitution would ensure that any new law, any new restriction on liberty, enjoys wide social acceptance, profits from an array of views during its consideration, and as a result proves more stable over time. The need for compromise inherent in the designs inherent in the designs. Where did I just lose my whole spot? enjoys a wide social acceptance, profits from an array of views during its consideration, and as a result proves more stable over time. The need for compromise inherits in its design, also aimed to protect minorities by ensuring that their views and voices and votes couldn't be ignored. All in all, Madison hoped that the Constitution's arduous requirement would result in less law and more freedom, and at the same time yield laws that are wiser, more respected, and more apt to protect minority rights. For Madison, down any other path lay calamitous risk. In governments where lawmaking is easy, he wrote, laws can quickly become, quote, so voluminous that they cannot be read, or so incoherent that they cannot be understood, and they may undergo such incessant changes that no man who knows what the law is today can guess what it will be tomorrow. The sagacious, the enterprising, and the moneyed few may be able to anticipate, influence, and even profit from so much shifting law. But the industrious mass of the people can do none of those things. In the end, law serves as an instrument only for the few, not for the many, sapping and ultimately destroying confidence in public institutions and law itself. Madison hoped differently for our new nation. He sought to ensure that Americans would live under the new rule of law, but not be crushed by law. Today, everyone likes to throw around the phrase rule of law, but just what does it mean? Even political theorists debate the question, but there are a few important features that nearly everyone can agree on. As Madison appreciated, the rule of law does not mean rule by law. Adolf Hitler blanketed Germany with laws, many secret and unknowable except for those in the Führer's favor. The rule of law demands more than that. It requires laws that are publicly declared, knowable to ordinary people, and stable. So, for example, new legislation generally cannot be applied retroactively to past conduct you cannot alter, but only to future behavior that you can control. The rule of law is usually understood as well to guarantee that disputes about what a particular law means will be decided by independent and neutral judges, so that even the unpopular and most vulnerable among us receive a fair hearing. There are just a few examples. In an effort to capture the spirit of the rule of law, the Oxford University philosopher Joseph Raz once called it a set of principles designed to, quote, constrain the way government actions change and apply the law to make sure, among other things, that they maintain stability and predictability and thus enable individuals to find their way and to live well. I'll remind you guys, during Tina's trial, they tried to retroactively change the laws.
Well, they tried to convict her
retroactively
under a law, under a law that was passed after what she did, and then they, cobbled it together with rule violations and COVID nonsense to make it like 4 felonies.
Yeah. Note that last condition. The rule of law is not an end unto itself. In large measure, it's about protecting individual liberty. Observance of the rule of law, as Raz said, is necessary if the law is to respect human dignity, a respect that entails treating humans as persons capable of planning and plotting their future. Or to borrow from Hannah Arendt, who devoted much of her life to studying totalitarian regimes, the rule of law seeks to protect, quote, man's power to begin something new out of his own resources. In drafting our Constitution, Madison and his colleagues prized these ideals. They sought to ensure that our laws would be publicly declared, knowable in advance, and the product of the democratic processes. They sought to ensure that disputes about their meaning would be resolved by neutral judges. But perhaps most of all, they sought to keep, quote, government off the backs of people and to allow them room to author their own lives. As Governor Morris put it during the Constitutional Convention, the excess rather than the deficiency of laws is to be dreaded most. On any account, the framers' experiment was an uncertain one. At our nation's founding, the notion that a people could govern themselves wisely and with due respect for individual liberties was nothing short of revolutionary. Past republics had sometimes flickered brightly only to die away quickly. Few around the world thought that democratic majorities would long respect minority rights or avoid devolving into mob rule and tyranny. Daniel Webster once called a republic a miracle, but he also warned that miracles do not cluster. And that which has happened but once in 6,000 years of human history cannot be expected to happen often. Even a quick look at our world today confirms his assessment. The conviction that people can both govern themselves and respect individual liberty along the way still faces skeptics and challenges. Paradoxically, one of these challenges may lie in law of itself. Some law is surely essential to our nation's flourishings and our well-being as individuals. But what happens to rule of law value when we demand even more from the law? When we insist on national rules before considering local solutions? And when we permit unelected officials to make more of the rules that govern us? What happens to our individual freedoms and to our aspirations for equal treatment under law? And what happens to our respect for law itself? Put another way, what rule of law values do we place at risk when we forget why the Constitution left so much authority to state and local authorities, why it sought to make lawmaking so hard, and why it insisted on vesting the lawmaking function in elected representatives accountable to the people in regular elections? These two are questions explored in the pages that follow.
Maidan Agan. Did you have something to say?
No, go ahead. We gotta skedaddle.
John Yates was working in the couple's furniture shop in 2015 when he learned of the Supreme Court's decision. By the margin of just a single vote, the court had ruled in his favor. As the majority saw it, the Sarbanes-Oxley Act may prohibit the destruction of logbooks, spreadsheets, financial records, and other objects designed to record and preserve information. But for all its expansiveness, the law does not reach red grouper thrown overboard. In a sense, it was a huge victory for the Yates family. The highest court in the land had overturned John Sarbanes-Oxley conviction. He and Sandra had won all the vindication of our legal system can afford. Still, you might forgive them for seeing things differently. The family's ordeal had lasted 8 years. They had endured proceedings before 3 courts and 13 different judges. I feel good, John said after the court's decision, but you've got to look at it from my situation. I've already done the time. I've already paid the price. I lost a lot of wages because of this, at least $600,000, he estimates. Really, as Sandra said, we lost everything we had. John hasn't been back on a commercial fishing boat since his conviction. The couple now lives in a triple-wide trailer and depends on Social Security income and the extra jobs Sandra manages. Meanwhile, Sandra estimates that the taxpayers spent as much as $11 million prosecuting the case. What happened to the federal officials who pursued John for all those years? After complaints emerged of heavy-handed and unfair enforcement against other fishermen like John, the Inspector General of the Department of Commerce launched an internal investigation. His final report dryly concluded that the agency's enforcement officials had created a highly charged regulatory climate and dysfunctional relationship between the agency and the fishing industry. But he added, the investigation hadn't been easy. It seems that a key enforcement official had destroyed many of his files in the middle of the investigation. An anonymous whistleblower described it as a shredding party. We can find no public record of the criminal charges being brought against anyone for destruction of those tangible objects. But when announcing the department's findings to Congress, the Inspector General said the quiet part out loud. How do you think enforcement officials would have reacted if a fishing company they were investigating had done the same thing?
Go him.
Well, while John was appealing his case, Sandra pleaded her family's case to the government this way, quote, "We are raising 2 grandchildren. We are simple people. The actions of these agencies were damaging. These children have been affected also. Monies that would have been for them are gone. They have not even been afforded family vacations anymore. Our lives are forever changed by this, and I don't believe these officers give a hoot who they hurt or why. John is a 60-year-old man who has been beat up by these rogue agents. Jobs are tough to get when you're in your prime. He's been reduced to odd jobs. I'm the primary provider for the family, and I am old and tired, but I will not lie down or give up. We are meager people and don't want much, but fair and professional treatment should be mandatory for all." Sandra's words are powerful, maybe even more so when you consider the fact that there was nothing particularly unusual about John's case, at least from one point of view. Federal agency officials had adopted a regulation setting the minimum harvesting size at 20 inches, only later changing it to 18 inches. Another agency official concluded that John had 72 undersized fish on board and 69 at dock. Meanwhile, Congress had adopted a broad law forbidding the intentional destruction of any tangible object in the face of a federal investigation. Without a doubt, a good argument could be made that John's alleged conduct violated this mix of statutory and regulatory rules. From another perspective, though, Sandra and John's experiences, like those of many others you will meet in the coming pages, invite us to consider how well we are doing as a nation in our aspiration to live under the rule of law, where ordinary people have room to grow, plan, and make their own way. Yes, our founders desperately wanted a nation of written laws, but from their study of history, they also appreciated the dangers that follow when lawmaking becomes too easy, when it is a task too far removed from the people, and when laws become too hard to find and too difficult to understand. The Roman Emperor Caligula used to post his new laws on columns so high and in a hand so small that the people could not read them. The whole point was to ensure that the people lived in fear, that most powerful of a tyrant's weapons, fear. Our founders wanted no part of that for us. As much as they revered written laws, they also knew that when we turn to the law to solve every problem and answer humanity's age-old debates about how we should live, raise our children, and pray, we invite a Leviathan into our lives. The ancient Greeks famously lived by a philosophy of moderation. They inscribed the phrase, Medon agon, nothing in excess, on the temple of Apollo at Delphi. It is a principle worth reflecting on when it comes to our laws today. If we don't, we may find ourselves asking a question Friedrich Hayek once posed, quote, is there a greater tragedy imaginable than that in our endeavor consciously to shape our future in accordance with high ideals, we should, in fact, unwittingly produce the very opposite of what we have been striving for?
It's only just begun.
Good one. I'm excited about it. I like this book, and
Amen.
it's a stark, you kind of come face to face with the problem, and yeah.
You got to think about the context of what the Yates went through, because that started in 2007, right as the kind of recession was starting to hit us, and industries like his got absolutely crushed in that. And, so furniture industry, there was no furniture industry in 2010, 2011, 2012. And, God bless those people who just destroyed a generation, a lineage right there. Kids are going to, be pisses me off. All right.
Yeah, me too. We have one Badlands boost from June 1st. Deuces Sweet says, just got caught up. Excuse me. Just got caught up on the final chapter. What a great book. I'm really looking forward to Cash implementing some of those changes he wrote about, and I'm going to miss that intro outro.
Well, we got a new intro outro. Peter Friedrich on YouTube gave us a super chat. I haven't said super chat in 5 years.
And Peter sent a super chat on Culture of Change last night, and I didn't see it until after the show ended. So thank you for that one as well, Peter. Appreciate you.
Yes. And Snack Cakes 802 gifted 5 subscriptions as well. Thank you guys so much. We deeply appreciate it. That helps us out tremendously, but so does hitting the thumbs up. So do that as well. And it's free.
And if you're watching us on replay and you'd like to support the show and, help us stay on the air, then you can give us a Badlands boost, badlandsmedia.tv/boost. We will read it on next week's show.
Yes. And for those on YouTube, I apologize, but you guys are about to go out as we play the outro. So we will see you guys tonight on Only Lands. I will not be there, but Ash probably will be.
I might be.
She might be. Well, so tune in. Brad and Abby Live is next, right?
Yeah, they're happening now, I think.
They're starting now.
So we're stepping on.